It has been a very interesting week here in LSAT land. Apparently, there is some apparent confusion about what exactly the settlement means between LSAC and the plaintiff, Angelo Gno, and his co-plaintiff, both of whom visually impaired, both of whom wanted LSAT logic games removed from the LSAT. LSAC did apparently settle and indicated that over the next 4 years, they will research alternative ways to test LSAT analytical reasoning, aka LSAT logic games, and that all test takers would be enabled to take an exam in the future without the current analytical reasoning, aka LSAT logic games section. That joint press release itself was fairly ambiguous, and the plaintiff's attorney, Jason Turkish, has made several statements to the media. I've spoken with him personally a few times as well, and he has indicated that all means all, that all test takers will be able to take a future LSAT without LSAT logic games, that enabled and required, not a big difference to him in his eyes, even though on the LSAT, those statements do mean different things. He indicated that within 4 years, LSAC actually agreed to remove logic games versus the more conservative reading, which would have indicated that LSAC will simply study alternatives over the next 4 years and then potentially in the future remove LSAT logic games. So some confusion there. The plaintiff's attorney, Jason Turkish, is actually sending an open letter to LSAC asking them to do a joint public press appearance to clarify their shared understanding of what they both actually agreed to. So there is some confusion there. I'm linking to this letter below this video if you would like to read it. The bottom line here is that we don't really know what is going on here. The plaintiff's attorney is saying one thing, LSAC released its own individual statement indicating something very different. The plaintiff's attorney appeared to go beyond the scope of the joint press release, saying within 4 years, all test takers will be taking an exam without LSAT logic games. They will be allowed to, and that will be the new test form, open to everybody, not just the visually impaired. LSAC, on the other hand, their individual statement was a lot more conservative, saying they're going to study, and should there be any changes to the LSAT, they will announce it far in advance. So everyone in the LSAT prep industry is waiting with bated breath to hear exactly what will change going forward. Since Jason Turkish, the plaintiff's attorney, has gone forward with this step, asking LSAC to, together with him, clarify that they are, in fact, on the same page, which I certainly hope they are, or else more legal battles may be in both of their futures. We'll see what happens. I expect LSAC will respond at some point in the near future. They can't let this go on too long, or can they? We'll see. Anyway, I'll keep you posted with updates as I hear them. Please feel free to reach out if you need anything at all as you move forward. And in the meantime, do check out that link below this video where I'm sharing the attorney's open letter to LSAC. In the meantime, I wish you all the best and take care.